with that said, I would like to now please turn it over to our speaker for today. This is Kirsten Hensa for HOA meetings, notice requirements, and so much more. Kirsten, take it away, my friend.
Thanks, Jeff. Good morning, everyone. Again, I'm Kirsten Hensa, and I am the managing attorney for the West Coast office of the firm. So, for those of you who are not familiar with the firm, we are an exclusive community association law firm. So that means that we represent your community associations, your HOAs, your condos, and your cooperatives throughout the state of Florida. That is our one and only practice area. So, we don't practice personal injury or bankruptcy, none of that. Anything to do with only community associations. We do have multiple locations throughout the state, so not sure where you're located, but our main office is in South Florida, in Pompano Beach, Florida. And then we also have offices in Palm Beach area, in the Orlando area, and as well as on the West Coast, which is located in Tampa. I've been practicing for going on 18 years, and I've been with the firm since 2010. All right, so without further ado, let me go ahead and share the slides.
All right, we see them.
Okay, that's a good sign.
Even better now. Okay.
All right. So, like Jeff mentioned, you will get copies of these slides at the end of the class. And again, I'm only going to cover notice and election requirements for HOA. So those communities that are governed under Chapter 720 of the Florida statute. This will not address anything related to condominium associations. So you're welcome to sit in if you're with a condo, but this is primarily for HOAs. All right, so, why are you here? You're here because you have continuing education requirements that you have to fulfill in accordance with Chapter 720 of the Florida statute. So in addition to your board certification classes, and I'm not going to talk about the specifics of all your educational requirements, but in addition to your board certification class, you have these continuing education classes to take. And the number of hours that you have to take will depend on the size of your community. So as currently written, if you are in a community that has fewer than 2,500 parcels, then you have to complete at least 4 hours of continuing education annually. If you're in a community with 2,500 parcels or more, then you have 8 hours of continuing education to complete. Okay. And this will satisfy one of those credits. All right, let's start with membership meetings. So when I say membership meetings, I'm talking about meetings at which owners vote. Okay, so let's kind of, start, sort of from the beginning. There are board of directors meetings, and then there are membership meetings. We'll talk about board of directors meetings in shortly in this program, but those are meetings at which the board votes and takes action. Membership meetings are meetings at which owners vote and take action. Okay, so sometimes the board will provide, updates on what's happening in the community. We'll talk about, potential projects or the status of certain projects. These kinds of reporting, can take place at board meetings and can also take place at membership meetings. But a membership meeting will typically be noticed if owners need to vote on something. Okay. So now within this bigger umbrella of membership meetings, there are two types of membership meetings that you would call as a board. There's the annual meeting of the members. And the annual meeting of the members is, if nothing else, the one meeting you will have each year, each calendar year. And it's at that meeting that you will be electing your directors. Okay, that's your annual membership meeting. Anything else other than your annual membership meeting would be called a special membership meeting. Okay. So when are special membership meetings held? Well, typically when either called by the board of directors or when at least 10% of the total voting interest of the association petition the board to call a special membership meeting. Okay. So those are the two main meetings. Now, for annual meetings, unless the governing documents require otherwise, notice of the annual meeting does not need to include an agenda. Okay, that's what Chapter 720 provides. Practically speaking, we recommend that you include an agenda for your annual meeting, whether it's to identify whether you're conducting an election and any other additional business that you'll want to conduct on that date. For special membership meetings, the statute specifically says that notice of special meetings must include a description of the purpose or purpose for which the meeting is called. So you need to include your agenda on special membership meeting notices. And then business conducted at the special meeting is only limited to the purpose described on the notice. In terms of notice requirements, all notices must include the date, time, and the location of the meeting, as well as include the agenda of the meeting. And then if the bylaws do not provide for giving notice to members of membership meeting, then the association must either mail, deliver, or electronically transmit notices to owners no less than 14 days before the meeting. Okay, so you'd have to look at the bylaws first to see if it provides any notice requirements for how you notice these membership meetings. And it might say, notice of membership meetings have to be sent out no less than 14 days, or it might have a range, no less than 10 days, no more than 60 days. Whatever that notice requirement is, that's what you follow. Only if your bylaws are silent on the notice requirement do you then defer to what the statute provides, which means you have to give notice at least 14 days before the meeting. Now, evidence of compliance with this 14-day notice requirement has to be made by affidavit, which must be executed by whoever provided that notice. So typically either your property manager or the secretary or any other authorized agent of the association. And you're essentially attesting that the notice was provided in accordance with your governing documents and or statute. Notice must be mailed or delivered to the address identified on the owner's mailing address in the official records of the association. So you'll provide notice to whatever address that appears in your records. Now, notice again can be mailed, delivered, or electronically transmitted. Electronic transmission means via email. But you would only email notices to those owners who have consented to receiving notices by email. Okay. Otherwise, you have to do the traditional method, mail or hand delivered. Now, in terms of electronic notice requirements, as I mentioned, the association may provide notice of any meeting by electronic transmission to any member who has consented in writing to receiving notices electronically, okay, whether it's via email or fax. Now, email addresses and fax numbers provided by members to receive notice by electronic transmission must be removed from association records when the member revokes consent to receiving notices electronically. Note that if an owner has consented to receiving notices electronically and has provided, an email address in this case, that email address does become accessible to all other owners. Okay, which means that if an owner requests the email address of some of the members, as long as that particular owner has consented to receiving notice electronically, that email address becomes accessible. If the owner later revokes consent to receiving notices electronically, then you must then remove the email address from your records. However, the association is not liable for any erroneous disclosure of the email address or fax number for receiving receiving electronic transmission of notices. Now, note that electronic transmission may not be used as a method of giving notice of a meeting called in whole or in part for a special meeting of the members to recall a director. So Electronic notices can be used for most membership meetings, except for purposes of recalling directors. Okay, broadcast notice. So in addition to sending notices to members the traditional way, the association also has the option through the board to adopt a procedure for posting notices and agendas of meetings on a closed circuit cable television system serving the association. So this could be a viable option for those communities that have a bulk service contract and has such a closed circuit cable television system. If not, then obviously this is not an option for you. And then also note the website posting requirement. So the statute was changed 2 years ago now that required by January 1st of 2025 for those associations that have 100 parcels or more, they need to have a website. So hopefully if you fall in this category, you've already established your website, which means that there are requirements for posting notices and agendas of meetings on those websites. Okay, so you have to post notice agenda of membership meetings at least 14 days prior to the meeting. The notice has to be posted in plain view on the homepage of the website or on a separate subpage of the website labeled notices. And then in addition to posting notices, you also have to post on the website any document that is related with the owner vote. So for example, if you're giving owners an opportunity to vote on amendments to your governing documents, right? Then those amendments would also need to be posted on the website. And the time frame for posting is at least 7 days before the meeting. Okay. Members' right to participate. So, as many of you may have already known, owners have the right to attend all membership meetings, as well as to speak at those meetings with reference to all items that are either open for discussion or items that are included on the agenda. Okay. And notwithstanding anything to the contrary that may be set forth in your governing documents, an owner has the right to speak on any item for at least 3 minutes. Okay, so that is a statutory entitlement. The association can, however, adopt reasonable rules governing the frequency, the duration, and other manner of owner statements. Now, membership meetings must also be held at a location accessible to physically handicapped persons if it is requested by a physically handicapped person who has the right to attend the meeting. And also note that any owner may tape record or videotape membership meetings. However, the board also has the ability to adopt reasonable rules governing the taping of the meetings. Okay. So in terms of quorum for membership meetings, unless you have a lower number already set forth in your bylaws, 30% of the voting interest of the association constitutes a quorum. Okay, so that means that first, take a look at your bylaws and see what your quorum requirement is for membership meetings. If it's lower than 30%, then that's the quorum that you default to. If your quorum happens to be silent in your bylaws, or if you have a quorum that is over 30%, as some older documents might have, then you default to the 30% quorum requirement, okay? And a quorum, again, quorum is the least number of people that must be present at the meeting in order for the association to continue with the meeting, okay? Now, decisions, unless otherwise required by law or your governing documents, decisions that require vote of the owners must be made by the concurrence of at least a majority of the voting interest present in person or by proxy at a meeting at which a quorum has been attained. So, certainly, if the statute requires a higher voting percentage, or if your governing documents require a higher voting percentage from owners on a particular issue, you go with that. Otherwise, the vote excuse me, that's required is a majority of the voting interest present at a meeting at which a quorum has been attained. What that means is, let's take an example of a community with 100 parcels, just for easy numbers. And let's say your quorum is 30%. So the first thing you would establish at a membership meeting is quorum. Presuming that the minimum number of owners present at the meeting is 30% of those 100 lots. Majority of the voting interest present at a meeting in which a quorum means is that you need to get a vote on the particular issue from a majority of those 30%. Not a majority of all the lots, but a majority of the 30%. Unless, of course, the governing document or the statute requires a higher percentage on a particular issue. Now, proxies, unless otherwise provided in the statute or in your governing documents, members have the right to vote in person or by proxy. Now, to be valid, the proxy has to be dated, include the date, time, and place of the meeting, and must be signed by the authorized person who executed the proxy, whether it's the record owner, a voting member, or voting representative, if the association enforces voting certificates, or some other authorized individual. Now, a proxy is effective only for the specific meeting for which it was originally given, and any adjournment of the meeting. However, it will automatically expire 90 days from the date of the original meeting. So what that means is that the 90-day proxy gives the association some flexibility to not necessarily adjourn and end the meeting, but rather you can recess and reconvene that membership meeting for as many times as necessary up to that 90th day, and then try to collect additional proxies for that particular vote to pass. There is a process to recess and reconvene a membership meeting, which typically requires a vote of the majority of the owners who are present at the meeting. It also requires that the minutes of the meeting reflect the date and time of the reconvened meeting. So if that's something that you want to potentially do at your next membership meeting, I encourage you to speak with your legal counsel to get additional information on how to properly recess and reconvene a meeting. Because once you adjourn a meeting, essentially the meeting is over. Okay, and then you would have to start the process again to get the votes you need. Now, proxies are revocable at any time by the person who executes it, and a proxy holder may also appoint in writing a substitute proxy to act in his or her place if the original proxy provides for that option. A copy of the original proxy can be used if it is a complete reproduction of an entire proxy. So, owners can email their proxies, can hand deliver it, can mail their proxies. That's all acceptable. Now, there are two different types of proxies. There's a general proxy and there's a limited proxy. And a general proxy essentially allows a proxy holder to vote however he or she sees fit on a matter that may be undertaken at the meeting. With a limited proxy, it will list the specific issues that the proxy holder may cast a vote for or on behalf of the voting interest, and then instructs the proxy holder on how to vote. Now, both limited and general proxies may be used to establish a quorum. Now, electronic voting. This has to do with owners, being able to vote on issues via, electronically via a voting platform. Okay. So, to institute electronic voting in the community does not require a membership vote. There's there's misconception about that. It only requires a board vote. The board essentially needs to adopt a resolution at a board meeting that's noticed at least 14 days prior to the meeting. And at that meeting, essentially, the board can, vote to institute electronic voting to allow owners to vote electronically. Now, owners still have to opt into the system. So it's up to the owners whether or not they want to vote electronically or they want to vote via the traditional method, right? By paper ballot or proxy if they are not physically present at the meeting. So board adopts electronic or institutes electronic voting, but owners have to consent in writing to opt into the system. So for those owners who do not consent in writing, who do not opt into the system, the board would have to send them the traditional paper notices along with the proxies, in the mail or by email if the owner has consented to receiving notices electronically. Now, I've included here basically some statutory requirements for what a resolution must include. But I would encourage you to work with your legal counsel to make sure that your board resolution complies with the statute. Also, the statute includes certain requirements that this voting platform must be able to do. So I'm not going to go over this in detail, but I've included here, the statutory requirements. So if you're on the board and you are looking to institute electronic voting for your community, certainly first you'd have to, vet out, some of the vendors, and these are basically the questions you want to make sure that you ask the vendor whether they can meet and satisfy these requirements, which I believe most do anyways, but you'd want to confirm that with the vendor. Okay. So that was membership notice requirements. Let's move on to elections for HOAs. So a vacancy on the board that is caused by the expiration of a director's term must be filled by election. Elections must be held at or in conjunction with the annual meeting of the members or as provided in your documents. So typically, your annual meeting is when you will be conducting your election. Now, importantly, elections must be conducted in accordance with the procedures set forth in the governing documents. So, unlike condominiums, which have to follow the election process that's in the statute and the administrative code, with HOAs, you have to follow the election that is in your governing documents. It's very common for boards to sometimes conduct elections in a different fashion from what is set forth in your bylaws. And sometimes boards decide to change the election process from what's in the bylaws by way of a rule or a policy. Doing that can subject your election to a potential successful legal challenge. Okay, so you should really follow the election procedure set forth in your bylaws. And if you don't like that procedure or you have been following a different procedure in the past, then the way to do this going forward correctly without a potential challenge is to amend your bylaws to institute the election process that you prefer to follow. Okay. So I know many HOAs as of late prefer to do a condo style election, right? With a first notice and a second notice and the inner and outer envelopes and notices of intent. That's all great. But you would need to amend your bylaws to institute that process if it's not currently already provided in your bylaws. Now, unless otherwise provided in your documents, a quorum of the members must be established in order to conduct an election and any other business of the association at the annual meeting. So unless you have a different election process set forth in your bylaws that doesn't require a quorum, then, quorum would be the first thing that you have to establish at your annual meeting. Okay. Unless also otherwise provided in your governing documents, directors are elected by plurality of the votes cast by eligible voters. Now, candidate eligibility. The statute provides that all members are eligible to serve on the board unless otherwise disqualified. And under the statute, a member is not qualified to serve on the board if the person is delinquent in the payment of any monetary obligation to the association on the day that he or she could last nominate himself or herself or be nominated for the board. Okay, so any monetary obligation means not only delinquent on regular or special assessments, but it can certainly include any unpaid fines, costs, attorney's fees that may not have been paid in connection with perhaps a collection matter, or any interest, late fees, if the association has the ability to charge those. Okay. The last date on which the individual can nominate himself or herself, well, we'll talk about nominations from the floor in the minute, but that's the cutoff date. So you have to be current by the last date by which you can nominate yourself for the board. Now, a person who has been convicted of a felony in Florida, or in the U.S. district or territorial court, or has been convicted of any offense in another jurisdiction, which would be considered a felony if committed in Florida, is not eligible to serve unless their civil rights have been restored at least 5 years as of the date for which he or she seeks election. And then the person who has any pending criminal charges for either forgery of a ballot envelope or voting certificate used in an election, or felony theft or embezzlement offense involving the association funds or property, or tampering with physical evidence, destruction or refusal to allow timely inspection or copying of any official records in furtherance of a crime, or obstruction of justice may not be elected to any board. Okay, nominations from the floor. So a member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. However, the statute does provide that if the election process set forth in your governing documents allow candidates to be nominated in advance of your annual meeting, the association is not required to allow nominations at the meeting. So if you have a process by which, for example, owners are allowed to send in their notice of intent to run for the board in advance of the annual meeting, if you take those nominations in advance, or there's any other process, then you can dispense with nominations from the floor on the date of the annual meeting. But again, this has to be in your bylaws. On election day, an election is not required unless there are more candidates than there are vacancies. And if an election is not required because either there's an equal or fewer qualified candidates than vacancies exist, and if nominations from the floor are not required, then those candidates can commence serving on the board at the annual meeting, regardless of whether there's quorum. Now, members have the right to vote in person or by proxy unless otherwise provided in your documents. So if your governing documents, your bylaws specifically prohibit voting for elections by proxy, then you cannot vote by proxy. If your governing documents, so if your bylaws permit voting by secret absentee ballot, okay, then the statute provides a specific mechanism of how you have to handle those ballots. It essentially provides for a 2-envelope system, very similar to what condominiums have to follow. So you're going to have an inner, what is referred to as an inner envelope, where the ballot would go into this blank envelope. You seal the blank envelope without any markings, and then you put that blank envelope inside another envelope, what is known as an outer envelope. And that outer envelope is going to contain blank lines for the owner of the property to sign their name and include their property address, lot number. Okay, so you would have to follow that procedure if your documents allow voting by secret absentee ballot. Now, unless your bylaws provide otherwise, directors will serve a 1-year term. If you want to change the term of directors, for example, 2 years or 2-year staggered terms, then you would have to typically amend your bylaws. Now, for election challenges, any challenge to the election process must be commenced within 60 days after the election results are announced. Typically, election results are announced on the date of the election. So pretty much at the end of your annual meeting. So that means you have 60 days from the date of the annual meeting within which to challenge an election. Now, election disputes between a member and association must be submitted to either binding arbitration with the division of condominium, which is with the DBPR, or must be filed with a court. And then if the election dispute is submitted to binding arbitration, then it must be conducted in the manner set forth in the condominium statute. Okay. So we just talked about election of directors. So now we'll talk about election of officers. So officers are your, president, vice president, treasury secretary, treasurer secretary, and then the bylaws might allow the board to appoint some additional secretaries or additional, assistant treasurers or any other type of, any other officer. Now, generally, officers are appointed by the board immediately following the election of the directors at the organizational meeting of the board. So an organizational meeting, and that's how it's typically referred to in the bylaws, is nothing more than a meeting of the board of directors at which you're going to appoint and organize your officers. So typically that meeting follows immediately, comes right after the annual meeting, but you might have the discretion in your bylaws to conduct that organizational meeting within a certain time frame from the annual meeting, typically within 10 days. Now, really, the only agenda item, the only business that should be really conducted at these organizational meetings is the election appointment of officers. Now, directors may not typically vote by proxy or by secret ballot at board meetings, except they can vote by secret ballot when electing officers. That's the only time they can vote by secret ballot. There's also no prohibition against changing officers midterm. So if an officer has resigned from their officer position, or if an officer is not doing what they're supposed to, you can have a meeting to reorganize and reappoint officers. Okay. Fraudulent voting activities. These changes to the statute were instituted, I guess, a couple of years ago now. So a person who engages in the following acts of fraudulent election voting activities commits a first-degree misdemeanor. So that includes willfully and falsely swearing to affirming an oath of affirmation, or willfully procuring another person to falsely swear to or affirm an oath of affirmation in connection with or arising out of voting activities, perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with the vote cast, to be cast, or attempted to be cast. Preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate. Menacing, threatening, or using bribery or any other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting. Then giving or promising directly or indirectly anything of value to another member with the intent to buy the vote of that member or another member, or to corruptly influence that member or another member in casting his or her vote. However, this does not apply to any food served, which is to be consumed at an election rally or meeting, or any item of nominal value which is used as an election advertisement, such as a campaign pin or sticker. Using also or threatening to use directly or indirectly force, violence, or intimidation, or any tactic of coercion or intimidation to induce or compel a member to vote or refrain from voting in an election. Okay. Also, effective July 1st of 2024, each of the following acts constitutes a first-degree misdemeanor: knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity; agreeing, conspiring, combining, or confederating with at least one other person to commit fraudulent election voting activity; or having knowledge of a fraudulent election voting activity and giving any aid to the offender with the intent the offender avoid or escape detection, arrest, trial, or punishment. Now, vacancies on the board, unless otherwise provided in your bylaws, a vacancy occurring on the board before the expiration of the term may be filled by an affirmative vote of the majority of the remaining directors, even if the remaining director constitutes less than a quorum, or by the sole remaining director. So what that means is essentially, if, let's take an example of a board of 5, if directors start resigning from the board and you have less than a quorum of directors left on the board, or let's say you have, one sole director left, the other 4 have resigned, without a quorum of the board obviously cannot function, cannot conduct business. And so the one and only function that sole director can do, however, is appoint directors to the board, at least enough to constitute a quorum. Okay. So once you get quorum back on the board, then you can conduct business. But that one sole director can still appoint the vacant seats. In the alternative, the board may hold an election to fill the vacancy, in which case the election procedures must conform to the requirements of your governing document. And unless otherwise provided in the bylaws, a board member appointed or elected to fill a vacancy occurring on the board before the expiration of the term only serves the unexpired term of that seat. Okay. All right. So let's shift to board meetings. Okay. So when does a gathering of board members become a board meeting? Well, the statute says that when a quorum of the board gathers to conduct association business, that constitutes a meeting, and it should be duly noticed, and owners are entitled to attend that meeting. Now, officers and directors of the association have fiduciary responsibility to the owners, which means that, among other things, they must act reasonably. Now, unless otherwise provided in your documents or the law, the association powers are exercised by the board, which means that unless those powers are delegated to a specific director or officer, no one board member should be making decisions for the rest of the board. I mentioned earlier on in one of the slides, directors cannot vote by proxy or by secret ballot at board meetings, except when appointing or electing officers. Now, members of the board may use email address as means of communication. So you can email each other, but you may not cast a vote on an association matter via email. Just like with membership meeting notices, all board meeting notices must also include a date, time, and location of the meeting, and must specifically identify all agenda items. Now, an assessment may not be levied at a board meeting unless the notice of the meeting also includes a statement that assessments will be considered and the nature of the assessment. Now, typically there are 2 main notice requirements for board meetings. Typically, obviously, you're going to have to first look at your bylaws to see what your bylaws provide. But unless your bylaws provide otherwise, Notice of board meetings must typically be posted on your community or association property at least 48 hours before meeting unless there's an emergency. That's with most general board meetings. Now, there is a statutory 14-day notice requirement. And again, this is unless your documents provide otherwise. So if your documents specifically require you to mail notice to the members of a board meeting, 21 days prior to the meeting, then you have to follow those notice requirements. Okay. Otherwise, the 14-day notice requirement applies to board meetings at which the board is going to adopt a special assessment or an amendment to a rule regarding parcel use. So if you're doing any of those two specific things, the statute requires that you either mail, hand deliver, or email notice of the meeting to those owners who've consented to receiving notices electronically at least 14 days prior to the meeting. And you also have to post notice of that meeting at least 14 days in advance. In addition to these other notice methods, the association may also adopt by rule a procedure for conspicuously posting the board meeting notice and agenda on the website for at least the minimum period of time for which notice is also required. If you adopt such a rule, then the rule adopted must include a requirement that the association send an electronic notice to members whose email addresses are included in the official records in the same manner as is required for notice of a meeting of the members. And the notice must also include the hyperlink to the website or application in which the meeting notice is posted. Now, also, just like with the membership meeting notice requirements, as of January 1st of 2025, for those communities who have 100 or more parcels, you also have to have a website or application, and you must post notice of any board meeting along with the agenda and any other document required for such meeting no later than the date required for the meeting notice. So if you have to post that notice 48 hours in advance, then you would equally post that notice and agenda on your website 48 hours in advance, along with any document associated with the board member vote. So if, for example, the board is considering hiring a contractor and is looking to approve a contract, then a copy of the contract would also have to be posted on the website. Okay. Members also have the right to attend board meetings and participate at these meetings. So all meetings of the board are open to the members, except there's two types of meetings that are not open to the members. Meetings between the board and its attorney with respect to either proposed or pending litigation, okay, or meetings held for purpose of discussing personnel matters. You would still notice those meetings, but you would include on the notice that these are closed meetings because you're either meeting with legal counsel or discussing personnel matters. Now, members have the right to attend all board meetings and the right to speak at board meetings with reference to designated agenda items. The board also has the ability and the authority to adopt reasonable rules governing frequency, duration, and other manner of member statements, including, for example, requiring a sign-up sheet for members to fill out wishing to speak. Now, unless the member's right to speak, unlike a member's right to speak at membership meetings, there is no statutory prescribed time limitation for members to speak at board meetings. There is no requirement in the statute that owners have the right to speak at least 3 minutes at board meetings like there is with membership meetings. But I think adopting a board rule that provides at least 3 minutes to owners for owners to speak at board meetings would be a reasonable rule. Also, owners have the right to tape record and videotape board meetings, and board meetings must also be held at a location accessible to physically handicapped person if it's requested by physically handicapped person wishing to attend the meeting in person. Now, compensation of directors and officers. A director, officer, committee member may not directly receive a salary or compensation from the association in connection with their performance of duties as a director, officer, or committee member, except under the following circumstances. So, participation by such person in a financial benefit accruing to all or significant number of members as a result of actions lawfully taken, reimbursement for out-of-pocket expenses, recovery of insurance proceeds, or if that fee or compensation is either authorized in the governing document or by a vote of the majority of the voting interest. Okay. So, grounds for immediate removal include a director officer charged by information or indictment with any of these crimes must be removed from office. So, forgery of a ballot envelope or voting certificate used in the election, theft, embezzlement involving association funds or property, tampering with physical evidence, destruction of or refusal to timely allow inspection or copying of official records in furtherance of a crime, obstruction of justice, and then any criminal violation under the HOA Act. Now, the board must fill the vacancy until the end period of the suspension or the end of the director's term, whichever occurs first. However, do note that if charges are resolved without a finding of guilt or acceptance of a plea, the director or officer must be reinstated for any remainder of his or her term. Okay. And if criminal charges are pending, the person may not be appointed or elected to a position as an officer or director of any association and may not have access to official records. Another ground for removal, a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association, they're deemed to have abandoned their seat on the board, creating a vacancy. So there's no affirmative act that the board needs to do to have that director removed due to delinquency. The statute says it becomes an automatic abandonment of their seat. Document posting requirements on association website, notice of any board meeting, agenda, and any document required for meeting must be posted no later than the date required for the notice. And then we've already talked about this, but again, notice of any membership meeting must also be posted on your website at least 14 days in advance, along with any document associated with an owner vote, which must be posted at least 7 days. And that's only for those associations who are subject to the website requirement. Now, meeting minutes. All meetings must have minutes taken. Typically, either the property manager or the secretary will take minutes. Now, minutes do not need to be a verbatim record. Boards tend to, or have this tendency of taking these, copious minutes, of everything that everybody said. That's not recommended. So your minutes really should just reflect the date, time, location of the meeting, who was present, the motions that were made, who made those motions, who seconded the motions, and then the vote. At times, it might be relevant to have maybe some description of what was discussed, but generally, that's the information that you want to limit your minutes to. Minutes must be maintained in written form or in another form that can be converted into written form within a reasonable time. And then a vote or abstention from voting on each matter voted upon each director present at the board meeting must be recorded in the minutes as well. Now, notice and adoption of the budget. You'll have to review your bylaws to confirm if there are any specific notice requirements for board meetings at which the board is going to be adopting the budget. Otherwise, if your bylaws are silent or don't have specific requirement, then notice of the board meetings at which a proposed budget will be considered and adopted must only be posted on association community property at least 48 hours before the meeting. Now, unless your documents require the board to provide a copy of the proposed budget to all owners before the meeting at which you will be adopting the budget, you're not required to do so under the statute. You may wish to consider sending owners a copy of the proposed budget in advance of the meeting so they have an opportunity to review and possibly ask questions, but there's no legal requirement. Now, after the budget is adopted, the association must provide each member with a copy of the proposed budget or notice that a copy is available upon request at no charge. And if an owner does make a request for a copy of the proposed or adopted budget, then you have to provide it to the member within the time frame set forth for inspection of records, which is within 10 business days of receiving the written request. And then again, you also now have, for those associations that are subject to the website requirement, you have an obligation now to post a copy of the budget on your website. Adopting special assessments, have their own specific notice requirements. So again, you're going to be looking at initially at your bylaws to see what your bylaws provide for noticing a meeting at which you can adopt a special assessment. If they don't have, if your bylaws are silent or don't have any requirement, or the notice requirements are not different from what the statute provides, then notice of the meeting at which a special assessment will be considered must be either mailed, delivered, or electronically transmitted at least 14 days before the meeting. Now, the statute does say that the notice of the meeting must include a statement that a special assessment will be considered and the nature of the assessment, and should identify the estimated cost of the assessment. Now, it's important that your notice complies with the statutory requirements as well as those in your bylaws, because when you, in the event that the owner does not pay the special assessment, when you turn over that account to your legal counsel for collections, they will require a copy of that notice of the meeting at which you adopted a special assessment to make sure that it conformed with the statute. Otherwise, the owner might have a basis to challenge the collection action. So you want to make sure you do it right from the beginning. And if you have any questions, then I would encourage you to discuss with legal counsel and possibly have legal counsel prepare that notice of meeting. Now, once levied, the association should send written notice to the owners of the special assessment and then allow the owners a reasonable time within which to pay the assessment. A special assessment that is not timely paid by the owner can then be collected in the same manner as you would with regular assessments through the lien foreclosure process. Regarding committees, the same meeting requirements will apply to meetings of any committee when a final decision will be made regarding expenditures of association funds, as well as to any committee having the power to approve or disapprove architectural decisions with respect to a member's lot. Okay. Fining and use right suspensions. I'm not going to go in detail about the process of fining and suspending use rights or voting rights. We do have a class where we talk about remedies and enforcement options. And we do discuss, fining and suspension of use rights and voting rights in more detail in that webinar. So if you are interested, then I encourage you to go on our website and take a look at the calendar, see when we might offer that class again. But there are certain notice requirements in Chapter 720 that apply to fining and suspension of use rights. So that's what I'll go over in the next few slides, and then I think we're done. So the association has the authority, as you may know, to fine and suspend use rights of an owner or an owner's tenant, guests, and invitees for failure to comply with the governing documents or association rules. Now, a fine or suspension cannot be imposed unless the board first levies the fine or use right suspension at a properly noticed board meeting. So that's the first step, right? The board needs to adopt the fine or suspension at a duly noticed board meeting. And as we discussed, you would notice that meeting in accordance with the requirements in the bylaws. Otherwise, this would only typically require a 48-hour posted notice with date, time, location, and agenda. Now, once the board adopts the fine or suspension cannot be imposed unless there's a committee hearing on that fine or suspension. The board must provide the violating owner with a 14-day written notice of the hearing. Okay, so there's that second notice requirement. The notice must provide the description of the alleged violation, the specific action required to cure the violation, and the date, location of the hearing and access information, which can be done by phone or held virtually. Now, the hearing must be held within 90 days after issuance of the hearing notice before a committee of at least 3 members who are not directors, officers, employees of the association, or spouse, parent, child, sibling of that officer, director, employee. And then within 7 days after the hearing, the committee must mail or email written notice to the violating party of the committee's findings related to the violation, including any applicable fines or suspensions that the committee approved or rejected, and how the violation can be cured. Now, the association may also suspend an owner's right to use the common facilities if the owner is more than 90 days delinquent on a monetary obligation due to the association through board action at a properly noticed board meeting. So if you're going to suspend use rights because the owner's been delinquent on any monetary obligation to the association for more than 90 days, you can do so at a duly noticed board meeting, which, unless your documents provide otherwise, it would simply be a 48-hour posted notice. Similarly with voting suspension, so association also has the ability to suspend an owner's voting rights if the owner's more than 90 days delinquent. And would also only require board action. So there's no committee hearing required. You would just notice this meeting in accordance with your documents, or at least 48 hours prior to the meeting. For the suspension to take effect, the written notice must be mailed, hand-delivered, or emailed to the owner, and if applicable, to the occupant, licensee, or invitee. And the suspension will end upon full payment of the delinquency. Okay.
Well, hey, no one's going to complain
And
when
we've
they
reached
get to
the
get out.
end.
Yeah, they get to get out of school early. You still get your 2 CEs, even though we got Kirsten got this done in an hour. Um, well done, my friend. So folks, Kirsten's
Okay.
going to look through some of the questions in the Q&A and address a few of them before we end the session. But I want you to all please listen up. If you haven't already done so, press the chat button so the chat module appears on your Zoom interface. The chat module is not the Q&A. It's not the same thing. The Q&A is where you were asking your course questions. So in the chat module, we're going to be once again placing the link for the required post-webinar form. You're going to click on that link, and after you click on it, it's going to take you here. It's going to open up on your browser to fill out this form. It's not as doesn't take as long as it looks, just a lot of clicking. Anywhere you see an asterisk, it's a required field. Over here, you want to make sure your email addresses match. Very important. That's where we send your certificates in a day or in a couple of days. And then the last thing, when you click the I'm not a robot box, wait until that circle stops spinning and you see a check mark. Then you can go ahead and submit it once all the other fields are filled in. And when you submit it, and this is the part that I know will come up, so please, please listen up so we don't have to be repetitive for everybody who does pay attention. Um, After you submit the form, this is the screen that shows up. You have 4 bullet points. The first bullet point, the word here is an active link. You click on it, and the slides from today will open up, and you can then save them or print them. Okay. We also have Kirsten's contact information, the firm website, and any course related questions right here. But again, please read the top. It mentions that certificates will be sent to the email address you enter on this form. So keep tabs on your spam and junk folders over the next few days. If it's 10 days from now and you still can't find your certificate and you think you were here for the whole time and you should have one, you can contact us via any page on the firm website. There's a form at the top that says certificate request. But again, we should have all of those to you within a couple of days. Charles, I'll place the link here in the chat again in just a moment. Kirsten, back to you for a little bit of Q&A. Oh, and folks,
Okay.
while you're welcome, and we encourage you to hang out for the Q&A because you'll learn a little bit more, after you fill out the evaluation, your requirement is done. You don't have to hang out if you don't want to. So I repeat, I know this will come up. I guarantee, I bet the house on it. The required part is over. After you fill out your online form, you do not have to stay if you choose not to. Kirsten, now for real, back to you.
All right. Let's see. So first question, the 14-day notice, does that require a notary? No, the notice doesn't require a notary, but the affidavit of mailing would need to be notarized. And typically the affidavit of mailing would only come into play if you have to mail notice to owners at least 14 days in advance. Does the agenda items let owners talk for only 3 minutes, or it can be more? Well, for membership meetings, the statute says that owners are allowed to speak at least 3 minutes. So the board also has the discretion to adopt reasonable rules. And so if you want to allow owners to speak for longer than that, that's certainly a business judgment. Does the owner or board member have to announce they're recording the meeting? I mean, certainly if the board is recording, you would announce, for owners. I mean, you can adopt reasonable rules that can require owners to let you know in advance, that they are recording so that it can be, noted. Let's see what else we got here.
And while you're looking, just a reminder to everybody, course-related questions that Kirsten is answering a few of them now. That's into the Q&A module. Do not post your class questions into the chat. The chat is for technical issues and for the evaluation link only. Back to you.
Let's see. Should all official meeting notices of an HOA board always include all agenda items? To be correct? Yes, that's correct. All notices have to include all agenda items that will be discussed at the meeting. And you should not be going beyond the agenda. How about rules for notices of other association related meetings like finings, beautifications? So any official board meeting at which you're going to be discussing, voting, taking action on any issues, those need to be designated on the agenda. So if you're going to talk about, fining, if you're looking to fine someone, adopt a fine, you would include that as an agenda. If you're going to be adopting rules, remember we talked if the rule concerns parcel use, that needs to also be noticed 14 days in advance. If the bylaws state 4 members of the board constitute a quorum, what actions can 3 or less board members perform legally? Well, that's why quorum requirements exist, because that's the minimum number of directors that would need to be present in order for the board to take action, to vote on things. So if you have less than a quorum, then you legally cannot take action on certain things. You can't vote on certain matters. The one and only thing that less than a quorum can do is appoint enough vacant seats on the board to have a quorum. Okay. Now, the next question is, if a board member attends on the phone, should that be done on a speakerphone so all attendees can hear? Absolutely. So directors can certainly attend meetings via speakerphone. So that's allowed, but it has to be in a way that the rest of the members can hear the director. All right, let's move on. If an HOA allows proxies of any kind in an election, the proxy becomes an official record open for inspection. This destroys the secret ballot concept. HOA should not allow proxies, just like condos. Your opinion, please. Well, again, your HOAs or elections are governed by what's in their bylaws. So if the bylaws allow voting by proxy and does not specifically allow voting by secret ballot or secret absentee ballot, then that's all you got. You got to do with what you have. If you don't like that system, then consider proposing an amendment to your bylaws to change it. Let's see here. Can a board member call into a board meeting and vote by phone at this meeting? Yes, a director can appear by phone, and their presence at the meeting via a speakerphone would be counted towards quorum, and they can also vote via speakerphone. Let's see.
And Kirsten, I'll take John's question. He had a question
Okay.
about a referral for a online voting company. We're not going to give a referral. There are so many of them out there. A lot of them are great. Some of them we've used with our association clients. So we know that it's a great resource, John. We agree with you. So the best thing you can do is check your local CAI chapter's website to look on there for some online voting companies that are in your area. I just posted the link as a response to your question. You could find your local chapter via the caionline.org website. Kirsten, back to you.
Quick question here. If the association has a Zoom meeting, does the association have to offer a place in person for those without a computer to go sit and see the Zoom meeting? So, I mean, there's currently no specific requirement to that effect. Many of you may have heard the condo statute was amended last year to specifically now require that if you're conducting a virtual meeting, now you need to have a physical location for that meeting. For HOAs, there's no similar requirement in the statute, but it has been the opinion of this firm that if you are going to give a virtual option to owners to attend the meeting virtually, that you do it in a hybrid system. So you still have a physical location for the meeting, and you would include the physical location of the meeting on the notice, and then also offer the virtual option for those who do not want to attend the meeting physically. This will minimize potential legal challenges, especially if there's an owner who's handicapped for some reason and wants to attend physically and can't, access electronic meetings, so forth and so on. Let me take maybe one more.
And while you're looking, anybody with education related questions, I'll cover those. We don't need an attorney for that one. So after Kirsten heads out for her appointments, I'll answer any of your education requirement related questions. So Edie and Eddie and a couple of others that have those questions, I'll cover those after Kirsten heads out.
Bup, 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 bup. Just to be clear, 30% is the maximum quorum requirement of membership meetings, regardless of the number in the documents? No. The statute says unless otherwise provided in the documents, quorum is 30%. I'm sorry, unless a lower number is provided in the documents, quorum is 30%. So if you have in your bylaws a quorum requirement that is less than 30%, that is the quorum, the requirement that will control. Okay. All right. That's it for today, folks.
All right. Sounds wonderful. Kirsten, excellent job as usual.